all of the stuff that they've done, which they think makes people's lives worse through litigation. They feel like it does a real damage to them, to the parties, and they also feel like it does damage to them personally. And so for them to feel like they're participating in something where people are really coming together in a real kind of peace, feels like even though monetarily they're making less money doing it, it gives them a lot more personal satisfaction. And I think it's this sense of professional and personal satisfaction that we all want as mediators, as lawyers, as anybody. And this path to do this is extraordinarily, everybody works harder, but it's worth it. Because at the end, if it really works, they feel like they've contributed to making the planet a little bit better.
The Center for Understanding and Conflict welcomes you to The Other Chair, a monthly podcast exploring the dynamics of conflict and how to bring the human issues to the table. Together with our guests, we explore how the power of understanding each other can lead to better solutions for people on both sides of an issue. We will also share tips for managing your own mediation practice, approaching conflict in the professional world, and ways to apply our understanding-based model in your personal life. Hello to our listeners, and welcome back to The Other Chair. Today we are taking a closer look at the evolving role of lawyers in mediation and what happens when legal culture reshapes a process that was meant to center the people in conflict. Our guest, who needs no introduction, is Gary Friedman, co-founder of the Center for Understanding and Conflict, and a leading voice in redefining how we engage with conflict. In this episode, Gary walks us through the legal profession's early resistance to mediation, how mediation has been adopted and reshaped by the courts, and what is at stake when lawyers dominate the process. Hello, Gary, and welcome back to The Other Chair.
Thanks, James. Happy to be here.
Always happy to have you. So we had a webinar earlier this week, and in that you had mentioned that your views on the role of lawyers in the mediation room or as part of the mediation process has evolved over the years. And so I was excited to invite you onto the podcast to talk more about that. I know that's been a central thesis to the understanding-based model and its growth and evolution in the legal system. And I knew that our listeners would probably enjoy hearing more about that. But before we jump into it, maybe take us through the quick history of the legal profession's kind of role with mediation or response to it in the early.
Yeah, thanks, James. Yeah, when I started to mediate, it was really a response to what I felt was a kind of grassroots feeling of people who went to lawyers who were dissatisfied, felt like when they went to lawyers, somehow they were disqualified from participating in decision making and that lawyers were running their lives. And people would blame the lawyers for the escalation of disputes, and it was all kind of beyond their control. And so the idea of mediation was, and my impulse to mediate was to help those people be able to kind of reclaim the power to make decisions that they could have, and that they shouldn't be disqualified from making decisions together just because they disagreed, but that they needed some help and that we were trying to empower the people. That was the phrase that we were using at the time. And of course, knowing that, the legal profession's first response was to just push back on that and say, oh, and what you're doing is illegal to their clients. You can't do that. And I was complained about to the Bar Association because they felt that I was violating the requirement that a lawyer not represent both sides. And my response was, I'm not representing both sides. I'm representing neither side. They're each representing themselves. And they didn't like that. But it became and they decided to investigate me. And as they did that, I said, I really welcome this because I think that this should be known publicly, that the Bar Association is taking this stand against mediation. The lawyers are taking this stand. And it's really I think it's just to preserve their own economic self-interest. So they backed off. And within a couple of years, I was invited by the Bar Association to come talk about what I was doing. So the first response to mediation was, no, it's illegal, you can't do it. That evolved in a matter of just a few years, late 70s, to lawyers saying to their clients, Mediation's a good process because they didn't want to be seen as being protective of their own monopoly, but they decided that it's a good process, but it's not for you, they would say to their clients. And very quickly thereafter, the next turn in the spiral of the evolution was, no, mediation is really a good thing. I've been doing mediation all my whole life. And then lawyers, and we had the very bizarre response, which was taking up a process that was really meant to be voluntary and shoving it down people's throats. And so mandatory mediation, mandated by the legislature in particular areas, came into play. And before we knew it, mediation was all over the place. And it was required. The tension that was there at that time was, well, what should mediation look like? And lawyers went to the kind of the lowest common denominator, which was, well, they were uncomfortable with the idea of mediators there working the way I was describing, which was for the parties to be empowered. And so they found what they were comfortable with, which was something that had been around for many decades, which is the judicial settlement conference, where lawyers would meet separately. I mean, a judge would meet separately with each side, shuttle back and forth, and then put the hammer down, try to scare the hell out of both sides, and make a deal. And so that's what they thought mediation was. And of course, it worked for the lawyers in a lot of ways because it was no new change. It just using a new word to describe what they'd always been doing. The goal was to empower the clients. So as mediation developed further, our alternative started to get classed as it must be that thing. And many people still, when you ask them today, what is mediation, their experience is what we call the settlement conference model of mediation, where there's lots of coercion used by each party, by the mediator. There's turn up the heat to make a deal, and separate meetings in order to force a deal, where that was kind of according to the realm, and that continues to be today. Now it's the most dominant way that people go through mediation. And lawyers now are at the center of the process. They used to be outside of the process, and then they came into the process. And then in various ways as it evolved, in family law or family mediation, lawyers didn't want to participate at all. And so that still continues to this day. People have what they call consulting lawyers, and they check with those lawyers, and those lawyers participate in that way, but usually not in the room. In the commercial area, it's very different because lawyers and their clients have a relationship that preceded the dispute. And because of that, lawyers want to be in control and they want to be part of it, and the clients want them there. And so that's become the norm. So this distinction between whether lawyers are in the room or not in the room has really nothing to do with what's actually works best, but has to do with this kind of historical anomaly.
Conflict manifests itself in many ways in our personal lives, for professionals in the workplace and for practitioners who have made a career bringing together parties in conflict through mediation practice. Each month, the Center for Understanding in Conflict hosts live webinars with featured guests discussing best practices and sharing their experiences for tackling conflict using the understanding-based model. And just so that I'm clear, my understanding, I believe there's a statistic, only about 5% of cases go to trial. Anyway, that may just be criminal trial, so don't quote me, I'm not a lawyer, but
No, that's right. Well, that's probably accurate.
Settlements were already most of the gig, right?
Yeah.
Many attorneys that I meet through the center have never gone to trial. And so how do attorneys approach mediation as an alternative or now as part of the process compared to the settlement conference from the attorney's perspective? Are they able to detach themselves from a desired outcome or the coercive factor of getting their clients to participate or accept certain things to move forward? Can you unpack that a little bit more?
Yeah, I mean, it's a dance, and lawyers are familiar with the dance, and particularly in the commercial area, their clients are familiar with the dance of negotiation. And so it really is, I mean, it used to be, and it should be still, that lawyers should sit down and negotiate with their clients or with their client for their clients, and they don't do it now. They wait now for mediation. Lawyers don't call each other up. They wait for the court to order them to mediation. They go to mediation, and that's become the norm. And lawyers being able to work out deals with each other, particularly involving their clients actively, has pretty much gone by the boards. And this kind of settlement conference model has become the norm.
So what impact does that have on the individuals, the parties in conflict who would have elected to mediation on their own in the past, but now are being compelled to do it, whether they like the idea or not? And what does that mean, especially through the understanding based approach, which is all about proceeding by agreement, choosing to be there and to give the process a try?
Yeah. No, I think the motivation to mediate we see is really critical to the success of mediation. And when I say mediation, I mean, I don't want to call it real mediation, but it's mediation where the parties actually make decisions together. That's what we see as the heart of the process. So that's really at the core of what mediation is about. So for people to understand the choices that they have that they're faced with, it's usually now it's the system, the judicial system kind of grinds them up. And if they start to go through that, they end up in this rather coercive process, unless they have reasons to want to do it otherwise. But there are a number of cases, many situations where people have disputes with each other. They feel and they fear that if they get lawyers involved at all, that it's going to escalate and it's going to turn into something they don't want it to. So they come to mediation often without lawyers, or sometimes with lawyers, and particularly people who've been trained in our model or other models similar to ours. They understand that lawyers can play a very constructive, very important supportive role, but it's not about them. It's about their clients and supporting their clients to be the decision makers. That that's a rather enlightened perspective that I would say most lawyers don't have, but increasing numbers do have.
And what lessons might one take away from these two different approaches? You mentioned family mediation often doesn't have lawyers almost by default, or lawyers, prefer not to be involved in that one, versus many of the alternatives where the court is kind of setting things up so that attorneys would like to be present. What are some of the key differences in how those mediations go? And then what are some takeaways that we can learn about those differences, either for or against, or maybe against isn't the right word, but pros and cons?
Yeah. So, you know, in an ideal world, from my perspective, I would be I would prefer that parties have lawyers and that lawyers be in the room and that they play a supportive role, supporting their clients to be the decision makers. Many lawyers, by either character or inclination, don't want to do that because they're used to being in control and they want to be in control. And so it takes kind of special lawyers, particularly self-confident lawyers, to support their clients to be there front and center, and they play a supportive role. So that is an underlying tension that's there between and many different approaches that people have depending on the kind of dispute they have, who's on the other side, and who the lawyer is on the other side. And so there are many different permutations and combinations here that look very different. But the basic question is, if lawyers are going to participate, are they going to participate in a way where they support the clients and play a very constructive, important role, such as advising their clients about the law? I do think it's two lawyers together talking about the law can get it clearer than any mediator can about what the law is. And I think that in the early days, I was very worried about the power that law would have over people. So I kept law out. And of course, the impact of that was it made law more powerful, so powerful you can't even speak of it. And of course, people would find out or have their impressions about what the law was anyhow. So I couldn't even achieve that. So over time, understanding how law itself can be constructive and be helpful to people becomes the focus of mediation. So our definition of mediation is for people to make their own decisions based on what they think is important and to find results that are better for both of them than to go to court And so we have, and the law is included in the process, but it's not to become the dominant thing, just as lawyers aren't to become the dominant thing. Law is to support people to kind of understand law as one of many possible reference points that they can use to come to their own decisions based on what they think makes most sense to them.
So just to clarify my understanding, as you mentioned in the early days of your work, especially with developing the understanding-based process, there was a preference, a leaning towards having just the individuals meet together and not necessarily the attorneys, unless that was what the individuals adamantly requested. But now you're saying that you see value in having the attorneys in the room, and so that's a bit of a shift or a noticeable evolution in that approach. Was there a key event that occurred in your experience, or was this gradual over time that you realized it may be better to have the law in the room, essentially? What was the key to that?
Yeah, I mean, I think what I learned from unhappy early experience was trying to keep the law out of the process was fruitless and not helpful people, and actually disempowered people. So powerful is the law that they can't even hear it and have that not take over from their own sense of what's right. Many lawyers have that feeling that, of course, the whole point of mediation is to mirror the result that would happen if the parties were to go to court. But in our approach and other people's approaches as well, law doesn't isn't hearing the law is just a passage. It's part of the conversation, not the end of the conversation. And so that has been something that's taken. And there's really that really goes back a long way. So I've been kind of giving this description of how things evolved. Many, 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 many times, lawyers, when they negotiate with each other, agree to results that are very different than a court would impose. And so that was an old tradition. Michael Friedman. But I think what lawyers realize is that, or they felt, was that they wanted to be sure that they're in protecting their clients, that they were also protecting themselves. And so to agree to results that are different than what a court would do actually made the lawyers feel vulnerable. They were afraid they could get sued by their clients. So sometimes they would put pressure on their clients not to do a deal that protected them more than it did their clients. So that tension is there in the lawyer-client relationship, remains that way even to this day. And so it becomes very difficult for many lawyers to kind of support clients to do what some lawyers would call oddball agreements, which just means something different than what would happen if they were to go to court.
Does this mean that there's a point potentially in the mediation process where the attorneys are negotiating with each other in the room with their clients, kind of co-negotiating, whereas in the past they may have met separately? And how does all that come together in a
Yeah, and
comfortable way?
yeah, in a lot of different ways. I mean, that what with lawyers in the room, they're often one question is who's doing the negotiating when lawyers are there with their clients. And in our model, we're hoping that the lawyers are supporting the clients to be the negotiators. But some lawyers are just kind of constitutionally unable to do that. But that's an agreement that we want to have between us as mediators and with the parties and the lawyers, that the clients will be the decision makers and be the active in the negotiation process. However, some some clients need more support from their lawyer, and it's really hard for them to feel like they might form their own opinion, but they're afraid of being steamrollered, so they want their lawyers to negotiate for them. I think in many of these caucus kind of mediations, that's what's really going on in the separate meetings. It's the lawyers that are actually doing the strategizing, the lawyers that are actually determining what the result is, maybe including the client, but it's mainly the action is between the lawyer and the mediator carrying back and forth offers and counter offers back and forth from room to room.
Throughout the year, the Center for Understanding in Conflict hosts in-depth basic and advanced certificate programs designed to train you to become effective mediators and conflict resolution professionals centered in the understanding-based model. Our training programs have been the gold standard in alternative dispute resolution for 40 years and is popular within the legal community with human resource professionals, ombudsmen, and corporate workplace mediation clients.
I understand in the agreements part of the process, kind of laying the ground rules that everyone agrees to, the client's going to lead the conversation. It's really their mediation. How does that happen in practice, especially when attorneys are very accustomed to letting their client know when it's a good time to speak, to not speak? Maybe don't say that. It might not help you, or do say that, reinforce it. How do you get a lawyer to sit on their hands during a mediation process and truly stay in the back seat?
Yeah, we don't want them to sit on their hands. We want them to be really active, and there's a lot of active things that they can do that are very constructive and positive for the process. To protect their clients, for example, is a goal that lawyers have. As a mediator, I have that same goal for them. I want their clients to feel protected, and I want them to protect their clients. But protecting them doesn't mean necessarily shutting them down and taking over from their participation as decision makers. So it's kind of critical that lawyers understand that they can protect their clients, support them, and not have to speak for them or shut them down or coerce them or try to coerce the other side. And it's a really different way of proceeding. And what we're seeing is as more and more lawyers are becoming mediators over time, they've come to understand this. And we see that there is a kind of evolution of the process, even in court, where there are settlement conferences now where even though there might be caucusing, it has much more of the spirit of mediation, particularly for lawyers on both sides that know each other or have had experience with that and don't feel like they have to do posturing for their clients or posturing to just kind of take away the power from their clients to find the solution that they want.
So if you could walk me through a scenario, the understanding based model offers a different way forward, where understanding is at the center of that. What role can lawyers play in the mediation room when the goal for them is not winning but understanding? And how does a lawyer reprogram themselves to do that? And what does that look like in the process?
Yeah. Well, first, protecting their clients is a very important role. The second is clarifying the law. What will happen if the parties don't go to court? One of the advantages of mediation is that without going to court, lawyers can talk about the law and give their clients a fairly accurate picture of what they think might happen in court so that the parties are in a position to decide how important the law would be. And now that means that they have to talk about the law in a very different way than, we have no risk and you're going to lose. And, a lot of times people talk to their lawyers. Either lawyer says, no problem, we're going to court and we'll win. And then the other lawyer says the same thing to their client. And the clients come to mediation. They say, how could this be? Well, the how this could be is let's drill down. Let's have the lawyers in the room and let's get really specific so that the clients are in a position of understanding what the legal risks and opportunities if they go to court. And lawyers can do this with a kind of accuracy that's enormously helpful to the clients. The other thing that lawyers can bring to this that I think is a really important role is when the goal of the game is not to win, or winning is coming up with the most creative solution, and you put lawyers' minds toward finding a solution that's going to work as well for the other side as it does for their own client. Lawyers can be extremely creative and be very, very helpful to the process and actually have it turn out to be something that's quite better than if they were just look to the law. So getting lawyers oriented in that way, that realizing that they don't have to just be looking in this kind of divide the pie up, get as much as you can. So let's see if we can make the pie bigger. And then when we divide it up, everybody has the possibility of coming out better than if they just had that smaller pie.
I'm thinking, how do we take a pie, which is I assume is what is at stake, and either goes all to one as the victor or is divided up amongst. How do you expand? Can you talk more about, when I think that, I think, finances, I think, the property in contention, that's the pie. So are you saying that, or is the goal to look at it not so in such material terms and that there's more here that extends outward, and in doing so, the pie, as you say, becomes larger because it includes more than just material goods. It includes, what your life's going to look like after, the things that are happening underneath to be considered. Can you talk a little bit more about that?
Yeah, it's really both. On a non-material plane, yes, making your life work better, having something that the result be something that really helps you respond to what you care about most in your life. We really think that's quite important. But also materially, you can be thinking about, ways of structuring a deal, take into account taxes or economics or various other components of the actual numbers that property represents, and thinking of dividing them up in a way that's better for both sides. So you see this all the time. For example, if you watch a movie, you look at any movie that you see, you'll see the credits, the beginning. It goes on and on and on, 42 different producers. Well, what's happened is people have figured out how to kind of enlarge the pie to divide it up. So many people get credit for being a producer, and it's better for all of them. So it's things like that that really help people think about materially and monetarily and also qualitatively, something that's really better for both sides.
This podcast is supported by our CUC Connect members, whose yearly membership includes free attendance to our live monthly webinars, 12 additional featured recordings of past training events, and support from our network of certified trainers for continued professional development. Consider joining CUC Connect today and dive deeper into the understanding-based model.
When you bring both lawyers into the room, they're invited in, they're there to support their clients, they're there to protect their clients. And crucially, you mentioned that both attorneys could be saying the same thing behind closed doors. You'll win this thing if we go to trial. If you bring the attorneys into the room to explain the nuts and bolts behind that, aren't you asking them to tip their hand on their strategy, both of them, how to leverage the law to be able to, increase a positive outcome for their client? And if so, how can mediators and lawyers work together to support people in staying connected and making decisions together with all of those dynamics at play?
Yeah, well, you put your finger on what I think is a really difficult task, which is for lawyers to talk about the risks their clients face if they were to go to court. No lawyer wants to do that unless the other lawyer is willing to do that. So you have to have a real understanding on the part of the lawyers that we're going to have a different kind of conversation, the kind of conversation you might have with your partner, legal partner, that where you're really talking openly about the risks and opportunities of the law. And so to have that conversation with the lawyers about whether they're willing to do that really is quite important. And also, more importantly, for their clients, to give them permission, to support them to do that, to talk about the risks that they face, all toward with the goal that if we can talk about that honestly, we can craft together something. If we have agreement about what the risks might be, that's going to be better for both than if they're going to court.
And if the mediation doesn't work out, if it does end up going to court, what are some positives to having gone through that process, even though now we're heading to a judge?
There are a number of things that can happen that can come from the mediation. Many times, people don't reach an agreement in mediation, but the conversation that they had in mediation allows them to negotiate with each other after the process, outside of the process, maybe as they're about to go to trial. They've had that experience of knowing having a chance to talk about what they care about in this dispute and understanding, or at least hearing the other side. So having that base is something that's kind of stays with them and might even survive a trial. I'll give you an example. The Ninth Circuit Court of Appeals many years ago started a mediation process. Ninth Circuit Court of Appeals, that means people have gone through a trial before they get to the Court of Appeals. And they're now appealing that decision, and they're about to get another decision from a court. Why would they be interested in mediation? Well, it turns out, having invested all that time and money in a process, turns out there are many, many disputes that until the parties actually have decided that they want peace with each other, the other side will be able to keep going. And so coming to some kind of real closure, real peace between the sides, both sides, is of enormous value for people, particularly take people in the same industry. If you looked at all the tech kinds of disputes, many of these different kinds of disputes, people can keep making trouble for each other, even after a court verdict, even after a verdict on appeal. So it is a chance to kind of face this and say, let's together put an end to this. We watch very sadly on the world stage, that unless both sides are really ready to have real peace, they're not going to have it. And so the court experience just becomes one more round for them to try to get under each other's skin or take advantage of the other or do better.
Final question I have for you, Gary. What advice would you give to lawyers and mediators who want to reclaim the mediation space as one for human connection and meaningful resolution that really stays in the hands of the parties?
Yeah, I think there's an enormous amount of. I'll tell you a quick story. Maybe 35 years ago, we had a training program, a one-day training program for litigators, where we explained to them and we gave them a chance to experience what mediation would be like. And at the end of the day, these are people died, and they really want to fight, and that's what they do, and they're really great at it. And for them to support their clients in mediation just felt like it was kind of anathema to them. But at the end of the day, they said they really liked it. So I asked the question, why? Why would you do this? And almost everyone came to the same conclusion, which is all of the stuff that they've done, which they think makes people's lives worse through litigation, they feel like it does a real damage to them, to the parties, and they also feel like it does damage to them personally. And so for them to feel like they're participating in something where people are really coming together in a real kind of peace, feels like even though monetarily they're making less money doing it, it gives them a lot more personal satisfaction. And I think it's this sense of professional and personal satisfaction that we all want as mediators, as lawyers, as anybody. And this path to do this is extraordinarily, everybody works harder, but it's worth it. Because at the end, if it really works, they feel like they've contributed to making the plan a little bit better.
Well, Gary, thank you for this thoughtful conversation and for, of course, all the work you do in expanding how we think about conflict.
Thank you, James. It's a pleasure.
Gary Friedman has worked as both a lawyer and a mediator for more than 40 years, and his work has helped thousands of professionals explore a different path, one based on understanding, not pressure. You can learn more about the understanding-based model and upcoming training opportunities at understandinginconflict.org.
Thank you to today's guest for being with us today, and to our CUC Connect members whose support enables the Center for Understanding in Conflict to bring new perspectives in the field of conflict resolution and mediation to you, our listener, in each new episode. You can find out more about today's episode, along with full interviews and additional information about conflict resolution and mediation using the understanding-based model at www.understandinginconflict.org.